Welcome to the course on medical law. This lecture will be about medical negligence and its legal implications. The concepts covered in this lecture are medical negligence, legal duties of doctors, rights of patients, laws relating to medical negligence, judicial approach to medical negligence. The keywords of this lecture are medical negligence, legal duty, legal harm, liability and rights of patients. Negligence generally means that someone has failed to exercise reasonable care and prudence to prevent injury or harm to another person. This concept was developed under the law of torts. Negligence can be found both in action as well as in omission. I will give you a scenario. A person owes a duty to another person to do a particular act, and if he fails to do so, it constitutes an omission. For example, a doctor owes a duty towards his patients. So, if he fails to do so, then it constitutes an omission. So, under the law of torts, negligence can be either by way of an action or by way of omission. The elements of negligence are: first, there should be a legal duty of care. So, a person who is alleged to be negligent must be having a legal duty of care towards the second person. Second is, the duty should be towards the plaintiff, the person who is alleging negligence. Third is, there is a breach of duty by the defendant. So, the person who is legally bound to take care of the duty has failed to do it. So, it constituted a breach of duty. Fourth is, there must be a damage to the plaintiff. So, because of this failure on the part of the defendant, some damage has been caused to the plaintiff. So, these are generally considered as the elements of the tort of negligence. Every patient has a right to receive medical care of reasonable standard, and it is the duty of healthcare professionals to provide the same. In India, medical negligence laws are put in place to ensure that patients receive proper care and adequate medical care and compensation in case of any harm caused by healthcare professionals. Let us see one case, Achudravu Haribau Kodua versus State of Maharashtra, which is a Supreme Court decision from 1996. In this case, the plaintiff's wife was admitted in a state government hospital and was operated. The doctors, while operating the patient, left the mop in the body of the patient, which caused formation of pus and eventually resulted in the death of the patient. The court held that the doctors who were performing the operation were negligent and thus was held to be liable. Duties of doctors towards patients. The Indian Medical Council Professional Conduct, Etiquette and Ethics Regulations 2002 provides the doctor's duties towards his patients. Following are some of the important duties of the doctors. No doctor should arbitrarily refuse to treat their patient. So, he has a duty to take care of the needs of the patient. A medical practitioner having any incapacity detrimental to the patient or which can affect his performance vis-a-vis the patient is not permitted to practice his profession. Medical professionals should be patient and must respect the privacy and honor of the patient. Medical professionals should not neglect the patient and nor should they withdraw from the case without giving adequate notice to the patient and his family. Medical professionals shall not willfully commit any act of negligence that may deprive his patient of the necessary medical care. So, all these that we discuss now are the duties of the doctor towards the patient. As early as in 1969, the Supreme Court laid down in Lakshman Balakrishna Joshi versus Dr. Trimberg Babu Godbol and another, that is a 1969 Supreme Court decision, that the doctor owes his patients certain duties which are: 1. Duty of care in deciding whether to undertake the case. 2nd. Duty of care in deciding what treatment to give. 3rd. Duty of care in administration of that treatment. A breach of any of the above duties may give rise to a cause of action for negligence, and the patient may on that basis recover damages from his doctor. So, as early as in this 1969 case, Supreme Court had laid down that doctors have a duty of care towards his patient, and any breach of that above mentioned duties will lead to a cause of action for negligence, and then the doctor will be responsible to pay damages to the patient. In the case of P. N. Thakur versus Hans Charitable Hospital, which is a 2007 decision from National Consumer Disputes Redressal Commission, a patient was admitted to a hospital which was done with the belief that the treatment will be given by qualified medical practitioners. But in this case, without the knowledge of the patient or his or her relatives, the patient was treated by a Unani specialist, and this led to serious issues for the patient. The National Consumer Dispute Redressal Commission held that hospital and the doctors treating the patient owed the duty to the patient for proper medical care, but failed to do so. Thus, it was apparent deficiency in service and constituted negligence. The liabilities for medical negligence can be of two types. One is the civil liabilities, second could be the criminal liabilities. So, in case of medical negligence, the doctor or the hospital authorities will be legally responsible to pay damages, that is the compensation for the harm caused. Apart from the civil damages, there may also be criminal liabilities under various legislations. Civil liabilities. Under the civil law, when it comes to medical accidents, the tort of negligence give rise to liability, and the evolution of the idea of duty of care in negligence as a whole constantly influences duty of care in medical setting. Under the civil law, the plaintiff has to show that doctor owed a duty to care, and he breached that duty by acting below the standard prescribed by the law. In such cases, the legal liability, that is the civil liability, can be established. Criminal liabilities. Simple lack of care will constitute only civil liability, but it will not constitute the criminal liability. To constitute criminal liability, a very high degree of negligence is required by the medical professionals. So, for establishing negligence as an offence, that is to establish criminal liability, an element of guilty mind or mens rea must be present. So, from the conduct of the medical professionals, the liabilities can be drawn by the court of the law. Dr. Suresh Gupta versus NCT Delhi, which is a 2004 Supreme Court decision, is an example in this regard. The court held that gross lack of competence and indifference to his patient's safety such that matter goes beyond compensation between subjects is necessary to hold the person liable for medical criminal negligence. The distinction between civil and criminal liability of medical practitioners thus lies in their conduct, which should be gross or reckless or of very high degree. So, mere negligence will only constitute civil liability, but if there is a mental element which is in the form of gross or reckless or very high degree of negligence, then it can constitute criminal liability as well. There are different statutes and regulations which governs the medical negligence. So, medical negligence, we can see provisions under the Indian Penal Code 1860, under the Consumer Protection Act of 2019, there could be contractual liability under the Contract Act of 1872, and medical negligence may be violation of Indian Medical Council Professional Conduct, Etiquette and Ethics Regulations of 2002. So, the comprehensive legal framework covering all these statutes and regulations cover the laws governing medical negligence in India. If you look at the Indian Penal Code 1860, various provisions of the Indian Penal Code deals with Negligence Act which endanger the life of another person. IPC provides criminal liabilities for negligence of medical practitioners. Section 304A provides that any person who acts negligently or rashly which resulted in the death of another not amounting to culpable homicide shall be punished with imprisonment, which may extend to 2 years or with fine or with both. So, a person is acting negligently or rashly which has resulted in the death of another person, but it is not amounting to culpable homicide. So, the element of mens rea is not as high as required in the case of culpable homicide, but it is sufficient to constitute an offence under 304A. So, in this provision 304A under the Indian Penal Code, if a doctor is acting negligently or rashly which has resulted in the death of the patient, then it would be an offence which is punishable under the Indian Penal Code. Let us see another section, which is section 337 of the Indian Penal Code. A person causes hurt to another by acting negligently or rashly as to endanger human life or personal safety of others shall be punished with imprisonment, which may extend to 6 months or with fine or with both. So, a person has acted negligently or rashly so as to endanger human life or personal safety, and because of which a person, which may be a patient, was hurt, then it is an offence punishable under 337 with 6 months imprisonment along with fine. Then there is another provision which is section 338. Any person who causes grievous hurt by act endangering the life or personal safety of others shall be punished with imprisonment, which may extend to 2 years or with fine or with both. So, in case of grievous hurt, so if grievous hurt is caused to the patient, then it will be an offence coming under section 338. But if it is only simple hurt, then it may be under section 337. So, if you compare all these three provisions, what we can see is the punishment or the offence committed will be in accordance with the damage caused to the patient. So, if the injury is of very serious nature, then the punishment under the Indian Penal Code is also very stringent. The Supreme Court in the case of Jacob Matthew versus State of Punjab, which is a 2005 decision, observed that to prosecute medical professionals under criminal law, it must be shown that the accused did something or failed to do something which in the given circumstances no medical professional in the ordinary sense would have done or failed to do. So, the degree of negligence which is expected from a medical professional to constitute criminal liability is much higher than the standard forms of negligence. If you follow this Supreme Court decision in 2005, the court has clarified that to constitute criminal liability, it must be shown that the doctor did something or failed to do something which in the given circumstances no medical professional in the ordinary sense would have done or failed to do. You can also refer to another case, Malay Kumar Ganguly versus Sugumar Mukherjee, which is a Supreme Court decision from 2010. Apart from the Indian Penal Code, medical negligence is also covered under the Consumer Protection Act of 2019. The Consumer Protection Act of 2019 is a law to protect the interest of consumers. A patient is also treated as a consumer under this law. This act provides safety to the consumers regarding defective products, dissatisfactory services and unfair trade practices. The basic aim of the Consumer Protection Act is to protect the right of the consumers by establishing authorities for timely and effective administration and settlement of consumer disputes. A person aggrieved by medical negligence by the medical professionals can file a complaint and claim compensation under the Consumer Protection Act of 2019. So, let us see one case, the Indian Medical Association versus VP Shanda and others, which is, the screen is flickering.
स्क्रीन पे वो ये हो रहा है दादा.
Was it okay?
हाँ ये
Let us see now.
बीच में आ जा रहा है दादा अचानक से.
Now it is okay. Okay, now it is okay. Can I start? So, let us see the case of Indian Medical Association versus VP Shanda and others, which is a Supreme Court decision from 1996. In this case, the Supreme Court brought medical practitioners under section 2(1) of the Consumer Protection Act of 1986. So, from 1986 Act, medical practitioners were not explicitly mentioned in the Consumer Protection Act, but however, the Supreme Court through its interpretation held that medical practitioners are also covered under the Consumer Protection Law. Subsequently, the Consumer Protection Act was modified in 2019 and a new enactment, the Consumer Protection Act 2019, was introduced by the Parliament. The new enactment explicitly mentions medical services as falling within the ambit of services as defined in section 2 clause 42. So, after the 2019 legislation, medical services also clearly falls under the ambit of the Consumer Protection Act. In Dr. Vigil versus Ambujakshi, which is a very recent decision from Kerala High Court 2022 decision, the High Court recently expressed that medical services would be covered under section 2 clause 42 of the Consumer Protection Act unless they were provided for free or under personal service contract. So, all the normal medical services provided to a patient on the basis of payment of a fee will be covered under the Consumer Protection Act. In Yashomati Devi versus Christian Medical College, the Supreme Court in 2020 held that the failure to conduct a CT scan of the patient for want of receipt of fee for the procedure constitutes deficiency of service or negligence, and thus the hospital was held to be liable. Similarly, in Shoda Devi versus Ripon Hospital Shimla, which is a 2019 Supreme Court decision, the Supreme Court enhanced the payment of compensation, which was fixed by the lower court, to send a loud message to the medical practitioners that their diligence and responsiveness have to be present for all the consumers. In Srimati Savida Garg versus Director, National Heart Institute, which is a 2004 Supreme Court decision, the Supreme Court laid down the principle that onus on the hospital to explain the exact line of treatment rendered and why a particular condition has occurred. So, after this decision, the onus to explain the exact line of treatment and why a particular condition had occurred is on the hospital which has given the treatment. Thus, the burden of proof is on the hospital in case of a medical negligence claim. So, now let us see vicarious liability in case of medical negligence. I will give a hypothetical scenario. During a recent hospitalization for surgery, a person was administered an incorrect dosage of prescribed medication, which caused cardiac arrest, and the patient was required to spend several days in the intensive care. It was unclear whether the prescription was written incorrectly or just administered improperly. So, it is uncertain whether it was the doctor, pharmacist or the nurse who was to blame, though they all were employed by the same hospital. Now, who is going to pay for this? Will it be the doctor, the pharmacist, nurse or the hospital? So, in this case, it is clear that some medical negligence has happened, but it is attributable to whom? There is no proof. It is not clear whether the medical negligence is on the part of the doctor or the pharmacist or the nurse, then whom can we blame for this? Here the principle of respondent superior, which means let the master answer, is applicable. So, under this legal principle, the employer is liable for the negligence of its employees in certain circumstances, which is commonly known as the principle of vicarious liability. So, in case of vicarious liability, the employer becomes liable for the actions of his employees. In Abarna Datta versus Apollo Hospitals, which is a 2002 Madras High Court decision, it was held that a hospital is liable for the negligence of its staff. Similarly, in Joseph Elias Papachan versus Dr. George, which is a Kerala High Court 1994 decision, the High Court observed that hospitals cannot escape from the liability for negligent acts of their staff, and persons who run the hospital are under the law required to give the duty of care. In the recent case of Maharaja Agrasen Hospital versus Rishabh Sharam, the Supreme Court observed, it is a common experience that when a patient goes to the hospital, he or she goes there on account of the reputation of the hospital and with the hope that due and proper care will be taken by the hospital authorities. If the hospital fails to discharge their duties through their doctors being employed on the job basis or employed on a contract basis, it is the hospital which has to justify the acts of commission or omission on behalf of their doctors. So, in this 2020 decision, Supreme Court has clarified that irrespective of whether the employment is on contract basis or on permanent basis, the hospital is vicariously liable for the action or omission on the part of doctors. Apart from civil liability and criminal liability, there could be disciplinary action against the doctors in case of medical negligence. Medical negligence could also be in the form of imposition of penalties pursuant to disciplinary action under the Indian Medical Council Professional Conduct, Etiquette and Ethics Regulations of 2002. The Medical Council of India, which is now replaced by the National Medical Commission, and the appropriate state medical councils are empowered to take disciplinary action whereby the name of the practitioner could be removed forever or suspended. There are some defenses which are available as a defense against medical negligence. Merely based on the fact that the decision of the doctor did not turn out to be favorable, he cannot be held against such error in judgment. The courts have observed that merely because the doctor chose a different procedure or treatment to cure a problem and it did not work as expected will not make him liable. Section 80 of the Indian Penal Code also protects medical practitioners from negligent accusations since the provisions define accident. So, in case of accident, a doctor will not be liable for medical negligence. Section 81, 87 and 88 of the Indian Penal Code also deals with acts committed to preventing greater harm and welfare of another person. Such actions are protected and will not lead to criminal liability on the part of the person who has taken the action. For example, a surgeon, knowing that a particular operation is likely to cause the death of Z, who suffers under immense pain, but does not intend to cause Z's death in a good faith for Z's benefit, performs that operation. A committed no offence. So, during the medical practice, there will be several scenarios where a doctor has to take the most appropriate decision. So, in such cases, the doctor will not be responsible for medical negligence. He must show that he has taken adequate duty of care in order to protect the health and the interest of the patient. Following are some of the defenses available for doctors against claims of medical negligence. One error of judgment. If a medical professional makes a reasonable and honest error in judgment while treating a patient, it may not be considered as negligence. So, if it is a honest mistake, then the doctor will not be responsible. Second is emergency situations. If a medical professional acted in good faith to save a patient's life in an emergency situation, they may not be considered as negligent. Third is contributory negligence. If a patient contributed to their injury or death through their own negligence, the medical professional may not be held entirely responsible. Let us see another case, Achyutravu Haribavu Kodua and others versus State of Maharashtra, which is a 1996 Supreme Court decision. The Supreme Court observed that the field of medicine skills vary from doctor to doctor and there are more than one method of treatment available and all are admissible. Medical negligence on the part of the doctor cannot be attributed so long as he is performing his duty with utmost care and best of his ability. So, what is required from a medical practitioner is to perform his duty with utmost care and best of his ability. In such cases, even if the treatment goes wrong, the doctor may not be held responsible under the civil law or under the criminal law. In M. Kochar versus Ispida Seal, which is a 2017 Supreme Court decision, the National Commission held that the treating doctor adopted the standard method. The patient was properly investigated and given proper medicines. It is known that no cure, no success is not negligence. Thus, fastening the liability upon the treating doctor is unjustifiable. Let us see the judicial approach on medical negligence. In Bolam versus Swayam Hospital Management Committee, which is a 1957 decision, it was held down that a man need not possess the highest expert skill. It is sufficient if he exercises the ordinary skill of an ordinary competent man exercising that particular art, acting in accordance with a practice accepted as proper by a reasonable body of medical men skilled in that particular art. So, if it is an accepted practice by a responsible body of medical men skilled in that particular art, then that is sufficient. It will not constitute medical negligence. The Bolam principle, developed in English common law, was adopted by Indian courts in different cases. In Lakshman Balkrishna Joshi versus Trimbak Bapu Godbol, the 2010 Supreme Court decision, the court applied the test and stipulated the standard to be applied by medical professional must be of reasonable degree of care. So, what is expected from a medical practitioner is to follow a reasonable degree of care. Similarly, in the case of Jacob Matthew versus State of Punjab, the 2005 Supreme Court decision, the court upheld the ordinary competence of medical practitioner as enunciated in the Bolam test. In the case of Arun Kumar Mangalik versus Chirayu Health and Medicare Private Limited, which is a 2019 Supreme Court decision, the court expressed its concern over the Bolam test and stated that the test need reconsideration in the modern time. To conclude, the medical professionals have legal and ethical duties toward the patients and they should attend to every patient with utmost care and attention. The legal framework for medical negligence in India is based on the Indian Penal Code, Consumer Protection Act, etc. The judgments of the Supreme Court and the High Court also guide medical negligence claims in India. Despite a exhaustive framework, Indian medical negligence jurisprudence needs reform to protect the rights of the patients. The references of this lecture can be seen here. Thank you very much for listening to the lecture. I hope you are enjoying the course.